Me go to one of the Snickers yet for Christmas.
I think I might have one more.
I've been going through-
I have been going through them. It's only March and. All right, are you Sulu Hampton?
Yes, ma'am.
And, Mr. Parker, will your client waive the formal reading of the motion?
Here we go, Honor.
Mr. Hamden, in cause number 24 DCCR 0759, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 7th of 2024 for a lesser offense of evading arrest or detention. I guess that really should say,
Yes, Your Honor, we should strike the with a motor vehicle.
any objection to
No
that
objection.
amendment? Did that. All right, so is the lesser offense of just evading arrest or detention, a class A misdemeanor? That was a 2-year deferred probation and has been extended for a year. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you provided a urine sample January 21st of 2026 that tested positive for methamphetamine, amphetamine, and tetrahydrocannabinol. And is that true or not true?
Yes, ma'am.
True or not true?
True.
And then count 2 alleges that you failed to pay your court assessed fees as directed. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 and 2 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
Have some documents here on the tablet that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection?
it's admitted. Is there any evidence that Mr. Hampton is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of evading arrest or detention.
This case moved fast, but don't miss what just happened. The defendant admitted to failing a drug test for methamphetamine and falling behind on court-ordered payments. Once he pleaded true to those violations, the legal fight was essentially over. The negotiated sentence, 60 days in jail, was already waiting on the other side. It's a reminder that probation can feel like freedom, but every condition attached to it matters.
Sentence you in accordance with your agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
All right, sir, is it Ledet or Ledet? And you are Carl Ledet? And Mr. Ledet, in cause number 25 DCCR 0579, you're charged with a special degree felony of an aggravated assault of a child, aggravated sexual assault of a child, from August 1st of 2024. Now, what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be a minimum of 25 years up to 99 years of life in prison without the possibility of parole. Do you understand?
Yes, ma'am.
And I have here on the tablet a document that you signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in the institutional division of the Texas Department of Corrections, obviously with the opportunity for parole. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, we'll get that done. Ms. French, is there any reason to believe at this point that there would be any change in that offer?
No, Your Honor.
All right, so I do want to make sure you understand, Mr. Ledet, that after today, there won't be, this offer will be off the table. You understand?
Yes, ma'am.
So what, Mr. Ledet, Mr. Parker represents you now. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
So, Mr. Parker, you're released. Mr. Ledet, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Yes, ma'am. Thank you.
Oh, nice.
Some days it takes a lot.
You wouldn't get my vote anyway.
Mr. Parker. I mean, we've been going, I'm still drinking coffee. It's cold from this morning. I haven't even finished my cup of coffee yet today. All right, sir,
Good.
Travis Lewis, and will your client waive the formal reading of the indictment?
He will, Your Honor.
States that they can proceed under 1244 of the penal code and punish this offense as a misdemeanor.
Thank you, sir. Mr. Lewis, in cause number 25 DCCR 0014, you're charged with the state jail felony offense of credit or debit card abuse, and that's from November 29th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
All right, Mr. Lewis, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of credit or debit card abuse. Sentence you in accordance with that agreement to a term of 60 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody.
Now this is a high-stakes decision. The state is offering 30 years in prison, but the defendant is rejecting the deal and choosing trial. That's a gamble with enormous consequences. If convicted, he's facing a minimum of 25 years and potentially life without parole. The question becomes, does he believe he can beat the case, or is he betting that a jury will see things differently than the prosecution?
That the law gives you the right to receive. Handing you the trial court certification, that shows that this was an agreement that I followed, and so you've waived your right to appeal. And I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.
Yes.
And this is an MTRP final reset. So are we just going through the motion?
This is the one that committed murder when he was on this. This is the guy we tried with Bruce, and the victim wouldn't show back up, so we had to plead him to the other ones. We have put him on probation, and that's when he got out. He built a new girlfriend, and we still waiting on that to be brought over.
So y'all still don't have the murder?
Hasn't been brought to us.
So I did discuss with Mr. Smith possibly setting or asking for a PR bond. He is on deferred probation.
No,
So
it's on
according
straight
to,
probation.
Hold on.
It's deferred.
It's deferred.
Right, yes.
So here's what I would ask, just so that everyone has an opportunity to prepare for any hearing.
yes, ma'am.
If you'll get something filed today, we can
Yes.
set it next week.
Okay,
Mr. Smith, if you will get with the whatever agency has not turned that over yet, explain to them what's going on with this case and what's about to happen. I don't know if that will encourage them to get something over more quickly. I know there's probably information they're still gathering, but we'll get that filed today. We'll
Yes,
get it
ma'am.
set next week for a hearing on the bond on this case.
Yes, ma'am.
Okay, I don't think I'll have a choice but to give some type of relief at this point.
Yes.
okay, thank
Okay.
you, Your Honor. Okay.
Good morning. Are you Zarek trustee?
Yes, ma'am.
Mr. Trustee, clause number 25 DCCR 0981. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that's from June 19th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And then in cause number 25 DCCR 0982, you're charged with the first-degree felony offense of aggravated robbery. And that's from June 19th of.
And just like that, another plea offer disappears. The defendant has rejected a deal that would have resolved both cases with concurrent 15-year sentences. From this point forward, the case shifts from negotiation mode to trial mode. Notice the judge's warning: unless some major new evidence emerges, this offer is likely gone for good. That's one of the biggest strategic decisions a defendant can make: accept certainty today or risk a much harsher outcome tomorrow. What would you do in that situation?
2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 5 years and up to 99 years or life. Do you understand? In each of those cases, I have here on the tablet some documents that you've signed with Mr. Reynolds showing that the district attorney's office has made offers in your case if you wanted to enter pleas of guilty for 15-year terms in each case that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. Let a jury decide if you're guilty and let that jury decide your punishment. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea of guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject those offers and move forward with trial?
Yes, ma'am.
All right, is there any reason to believe that there's any other information out there that would change that plea offer?
Not at all, Judge.
So I do want to make sure you understand, Mr. Trustee, that after today, I will not accept this plea offer or agreement unless there is some new evidence that comes to light that Mr. Reynolds or your attorney, or the state's attorney doesn't know at this point. And so we'll get it placed on that trial docket and Mr. Reynolds will begin preparation for trial. All right, you can go back with the bailiff.